You cannot claim leave to remain on the basis that you are a father or you are a mother of the British child, and Home Office should grant you a leave to remain because your child is British. No, you need to satisfy. You must satisfy the caseworker or decision maker that you have a genuine and subsisting relationship with your British child. And if the Home Office refuses your application for continue to live in the UK, that will breach your human rights, Article 8, private and family life. To prove your genuine and subsisting relationship, you must provide evidence to the Home Office. Another thing, some people, especially the separate parents, what they do, they made an application. Well, they submit an application for leave to remain on the basis they have a British child. Some people provide, birth certificate or copy of the passport, and think that is the proof of my relationship. No, you must prove that you have subsisting relationship. If your child is not live, if your child doesn't live with you, if you don't live with your child, then you must provide evidence that you have contact. You involved in child life. And types of evidence provide is either a letter from the mother must stated your contribution to the child life, how you connected, and if you lose contact, how it will affect your child. This letter is very important. The child mother must also give her bank detail, give her evidence of identity, a proof of address where the child is living. If the child is in school age, then you must get a letter from the school. If you take the child in GP, you must get a letter from the GP that you are the person in primary contract and you take that you attended at the appointment with the child. So that form of evidence you must provide. But most of the cases where the parents are separated is sometimes, most of the cases, impossible to get all this evidence. What you can do? Well, if you don't have any contact with your child, you must establish contact before you make the application to the Home Office. To do that, you need to make an application to the Family Code C100, child arrangement application. You need to submit this application. If you submit this application, if the code grants you a contract, either weekly or monthly or directly or indirectly or in the contact center, you can't still provide this code decision or other code correspondence to the Home Office to establish your relationship, because all the children proceedings is private and confidential. You can't disclose anywhere without permission of the court. Even with the permission of even with consent of the other parents, you can't disclose it. If you do, firstly, this is a contempt of court. Secondly, the Home Office will not take into account. Firstly, because Home Office know that you don't have permission, so you can't produce it. They will write you a letter that, look, we can't. If they are very kind, they will write the caseworker will write a letter that we can't see this evidence because you don't have permission. If he's not kind, they will state your report to the court, family court, to the judge that this what being disclosed without the court permission is contempt of court. You will face the contempt of court proceedings. So what you need to do in that case, firstly, when you submit the application C100 child arrangement order, there will be a couple of hearing the child arrangement application. I'm experienced because I do practice as family law as well. So firstly, first appointment direction, second FD or first dispute resolution appointment, and then either might be fact-finding hearing or maybe not fact-finding hearing, then welfare hearing, then the final hearing. So all sort of a couple of hearing you will see in the family code if the things goes not well. So in any of these hearings, you need to seek permission from the court to disclose the court proceedings to the Home Office. If the court give you permission, then you can disclose the a court decision to the Home Office. Without that permission, you can't disclose. So, what you need to do, you should have advice. You should get the advice from your lawyer that you should seek permission from the court, disclose the children associated document court order to the Home Office to establish that you have contact. Now, you shouldn't seek this permission at the first hearing, or you shouldn't seek a right in the child C100 children application from that you want permission from the court to disclose this document to the Home Office. Otherwise, your primary purpose will be to get visa, and you are using your child or the children proceedings as a trump card to get visa in the UK. If this is to be your purpose, or if this is to be the case, in that case, the family court might not grant you firstly contract, or secondly might not give you the permission, because all the purpose of the Children application is the best interest of the children. And if the court see, well, you make this application not for children's best interest but for your interest, outcome might be different, right? And of course, most of the cases there is a decision as well. If the fathers get leave in the UK, he can involve in child's life. He will have a contribution, and this is the best interest of the child. There are court decision about it. So when you seek permission, you must give an argument to the court that because of the best interest of the children of my child, I should have permission. And where the authority is from that case, I can remember, but I have notes from that case. Law is a case from the High Court, another case from Supreme Court, where decision was the father should have right to, if the father get leave to remain, this is the best interest of the children. So this is a brief tips. Those whose relationship break up have a British child. If you want to make this application, you should follow these tips. Thank you very much. All of you today.